The vast majority of individuals won't discover this until the window has closed. It's not due to concealed facts, it's not due to excessive complexity, but rather because the developments that silently transform countless lives seldom become viral online or appear as newspaper headlines. These developments unfold within judicial chambers. These developments emerge through legal terminology that typical citizens rarely encounter. And when ordinary Americans finally recognize that something has shifted, the economic ramifications are already in motion. This is precisely what recently occurred. The highest court in our nation just delivered a unanimous decision. Each individual justice, spanning the entire ideological spectrum from one extreme to the other, reached identical conclusions on the same matter. And their determination has irreversibly altered the retirement landscape across our nation, not on a temporary basis, not within a single jurisdiction, not affecting a select demographic, but irreversibly throughout the entire country. For everyone maintaining a pension plan, allocating funds toward a 401k account, collecting Social Security payments, or having ever structured a financial choice on the belief that the retirement regulations they organized around would remain intact when retirement arrived. This decision directly affects you. And why this carries such enormous weight at this precise moment before media coverage intensifies is that the safeguard it establishes won't automatically locate you. You must comprehend it initially because a highest court determination is only as effective as those who comprehend how to utilize it. So let's discuss what precisely transpired. Why unanimous agreement emerged among justices who typically disagree on virtually everything, and why legal experts are already labeling it among the most significant retirement determinations across the previous 5 decades. But initially, you must comprehend what was genuinely on the line because this case didn't commence as a transformative occasion. It commenced as one individual's unwillingness to accept that authorities could modify the regulations after the competition had already concluded. Picture dedicating 3 decades constructing an existence around a collection of commitments, not casual commitments, legally binding ones. Commitments documented within policy, integrated into the retirement infrastructure. You allocated toward every individual payment, every individual year. You structured choices based on these commitments. You selected a public service vocation because the pension calculation made it worthwhile. You remained in a jurisdiction you might have otherwise departed because the retirement taxation framework created financial logic for your future. You determined your accumulation rate, your retirement timeline, your investment approach, everything around a structure that authorities themselves established and encouraged you to depend upon. And then one moment, without your participation, without your approval, and with complete disregard for the decades of preparation you had already finished, authorities modified the regulations, not moving forward for incoming employees, but retrospectively for individuals already invested deeply within the infrastructure, individuals who possessed no practical means to restart. This is what occurred to the pensioner at the foundation of this case. And this is the circumstance the highest court was requested to evaluate. Not whether authorities possess the authority to revise legislation. They do. Not whether retirement infrastructures can undergo reform. They can. The inquiry the court was presented was considerably more precise and considerably more impactful. Can authorities modify the retirement regulations in a manner that directly damages individuals who already structured their complete financial existence around the preceding regulations? And the response delivered with complete consensus by every single justice was negative. Not without satisfying an exceptionally elevated constitutional threshold, not without proving that the modification is warranted enough to supersede the decades of genuine human preparation that were constructed on the foundation of the initial legislation. To comprehend why this response is so meaningful, you must comprehend what the court recognized as the fundamental legal principle at the foundation of the case. The justices concentrated on something termed reliance. It represents a legal framework, but the concept underlying it is something every individual instinctively comprehends. When you structure a significant life choice based on a regulation that exists, when you dedicate years of your existence and thousands of dollars of your resources to an infrastructure because of how that infrastructure operates, you have depended on that infrastructure. And when authorities establish an infrastructure specifically engineered to influence your extended behavior, specifically engineered to motivate you to accumulate, to allocate, to prepare decades into the future, it cannot subsequently remove the foundation from beneath you without addressing the ramifications. This is what reliance signifies. And what the highest court just stated with complete consensus is that retirement preparation represents among the most compelling examples of reliance that exists within American jurisprudence. Because retirement isn't a temporary choice, it isn't something individuals reconsider every few years and simply modify. It represents a multi-decade dedication constructed on the belief that the regulations will maintain sufficient stability for the strategy to succeed. Prior to this determination, jurisdictions possessed tremendous authority to alter retirement-connected legislation. They could modify pension calculations. They could implement new taxation on retirement revenue. They could elevate the threshold at which complete benefits became accessible. And they frequently did, justifying those modifications by contending that authorities require adaptability to control budgets and address economic situations. This contention isn't illogical on its surface, but it disregarded something vital. It disregarded the human beings on the opposite side of those policy modifications. The educator who dedicated 25 years in a classroom because the pension at the conclusion made the reduced compensation worthwhile. The firefighter who never modified careers because the retirement framework was component of the complete compensation that maintained the job financially sustainable. The pensioner who liquidated their residence, departed their neighborhood, and relocated across the nation specifically because one jurisdiction didn't impose taxation on pension revenue only to observe the legislature quietly implement that taxation 3 years following the relocation. These aren't theoretical individuals. These are the individuals this determination was decided for. And what the highest court has now stated is that their choices, their years of preparation, their demonstrations of reliance on the legal structure authorities established merit constitutional safeguarding. Now here is where this determination distinguishes itself from anything that has preceded it. The court didn't merely state that reliance carries significance. The court instituted a 3-component constitutional examination that every jurisdiction must now fulfill before it can modify retirement-connected legislation in manners that damage individuals who depended on the preceding regulations. And vitally, the court accomplished something that transforms the complete balance of authority between individuals and authorities in retirement disagreements. It transferred the responsibility of verification. Prior to this determination, if you were a pensioner challenging a jurisdiction policy modification, the legal infrastructure positioned the weight of verification on you. You had to prove with legal representatives and documentation and resources that most pensioners simply don't possess, that authorities acted inappropriately. The jurisdiction sat in the position of authority, and you had to struggle upward to challenge it. The highest court just reversed that. Under the new constitutional threshold, the assumption commences in your favor. The jurisdiction must now prove that its policy modification is warranted despite the reliance individuals positioned on the initial legislation. The jurisdiction must verify that it satisfies the constitutional examination, not you, them. This transformation isn't a trivial technical modification. In the legal realm, who bears the responsibility of verification frequently determines who prevails. By positioning that responsibility on authorities, the court has fundamentally restructured the authority relationship between retirement strategists and the jurisdictions that regulate their benefits. For the initial time in American legal chronology, the financial choices millions of individuals have structured about their retirement are being acknowledged not merely as individual choices, but as constitutionally safeguarded demonstrations of reliance that authorities must honor. And this acknowledgement modifies everything about how retirement legislation will function moving forward. But before we advance any further, let me be transparent with you about something because I believe the most valuable thing this platform can provide you is not merely information. It is precise information communicated without the type of sensational exaggeration that leaves you more bewildered than when you began. This determination doesn't signify that retirement legislation is permanently frozen. It doesn't signify that jurisdictions can never implement modifications to pension infrastructures or taxation frameworks again. What it signifies is that the threshold for implementing those modifications has been elevated substantially. Jurisdictions can still act, but they must now verify that their actions honor the anticipations of the individuals who depended on the preceding regulations. This distinction carries significance because this determination isn't a guarantee. It represents a safeguard. And like all safeguards, it only functions for the individuals who comprehend it sufficiently to utilize it. So, in the subsequent component of this analysis, we are going to become precise. We are going to discuss which categories of individuals stand to gain most directly from this decision. We are going to examine precisely what the three-component constitutional examination signifies in application, and how judicial systems will implement it when jurisdictions attempt to modify retirement-connected policies in the future. We are also going to discuss the actionable measures that retirement strategists, financial consultants, and constitutional legislation experts are already recommending in reaction to this determination. Because the individuals who respond to this information now, who record their reliance, who comprehend their safeguards, and who arrange their retirement approach around the new legal environment, are the individuals who will be best safeguarded if and when jurisdictions attempt to challenge against the parameters this determination has instituted. The highest court has established a boundary. What occurs subsequently depends on how equipped you are to defend behind it. There are particular occasions in legal chronology where a singular decision modifies the environment so thoroughly that everything preceding it appears different in retrospect. This is among those occasions, and to completely value what it signifies for your retirement, your accumulations, and your extended financial stability, you must comprehend precisely who this determination safeguards most directly. Because while the constitutional framework applies extensively, there are particular categories of Americans for whom this decision materializes at a vital moment. And there is a substantial probability that you or someone you value falls into at least one of them. The initial and most immediately impacted category is public sector workers, educators, firefighters, law enforcement personnel, medical professionals working in government hospitals, municipal employees, and administration personnel across all 50 jurisdictions. Millions of Americans who selected vocations in public service, not exclusively because of the occupation itself, but because of the retirement framework connected to it. Public pensions were engineered as an exchange, reduced compensation in return for assured extended benefits, established calculations, foreseeable outcomes, stability at the conclusion of a vocation dedicated serving the community. For decades, employees entered those infrastructures with defined anticipations. They understood how many years they required to serve. They understood how their ultimate benefit would be determined. They constructed their complete financial existence around those figures. And then, as pension infrastructures across the nation commenced confronting funding deficits, something concerning commenced occurring. Legislators commenced altering the calculations. Retirement thresholds were elevated. Cost of living modifications were diminished or removed. Benefit determinations were reorganized in manners that provided substantially less than what employees had been committed when they initially joined the infrastructure. In numerous instances, these modifications were implemented not merely to incoming workers, but to employees already decades into their vocations. Employees who possessed no reasonable capacity to restart in a different sector, recalculate their financial future, or recover the years they had already contributed to the infrastructure under a thoroughly different collection of regulations. The highest court's consensus determination positions direct constitutional examination on precisely that type of modification. If a jurisdiction attempts to diminish pension benefits for employees who joined the infrastructure under a particular calculation and dedicated years depending on that calculation, those employees now possess a substantially stronger legal foundation to challenge the alteration. The court's reliance threshold acknowledges that selecting a vocation in public service, allocating to a pension infrastructure for 20 or 30 years, and structuring your financial future around an established benefit framework is among the most transparent possible demonstrations of extended reliance that exists. Modifying those conditions retrospectively isn't a budget modification. It represents a violation of the foundational agreement that brought those employees into the infrastructure initially, and the court has now stated that violation carries constitutional ramifications. The subsequent category with a direct and compelling stake in this determination is pensioners and approaching pensioners who selected where to reside based on jurisdiction retirement taxation policies. This category is larger than most individuals acknowledge, and the financial implications for them are substantial. When Americans approach retirement, among the most crucial financial variables they assess is how their jurisdiction treats retirement revenue. Some jurisdictions impose no revenue taxation whatsoever. Others exclude pension revenue completely. Some exclude Social Security benefits from taxation. Others provide partial exclusions for distributions from retirement accounts like 401ks and IRAs. These differences aren't insignificant. For a pensioner existing on a restricted revenue, the difference between residing in a jurisdiction that imposes taxation on retirement revenue substantially and one that doesn't can total thousands of dollars every individual year. This is capital that directly influences housing expenses, healthcare accessibility, daily expenditures, and existence quality. So individuals structure choices, significant life-altering choices. They liquidate residences they occupied for decades. They depart neighborhoods where they nurtured their families. They relocate hundreds or thousands of miles to a different jurisdiction because the retirement taxation framework creates extended financial logic for their circumstances. And they structure those relocations with a reasonable anticipation that the policies they are relocating for won't be reversed the instant they have completely dedicated to the new destination. Under the legal atmosphere that existed prior to this determination, jurisdictions retained extensive authority to alter those taxation policies. A legislature could determine years following thousands of pensioners had relocated specifically for the taxation advantages to implement new taxation on retirement revenue or remove existing exclusions. From the authority's viewpoint, that was merely taxation policy development. From the pensioners' viewpoint, it was a financial ambush. The highest court's reliance threshold now establishes a meaningful constitutional contention against precisely that type of reversal. If you relocated in retirement based on particular taxation policies that existed at the moment of your relocation, that relocation and every financial choice connected to it may now qualify as a safeguarded demonstration of reliance. The jurisdiction cannot merely reverse the policies that motivated your choice without now having to fulfill the constitutional examination the court has instituted. This represents a safeguard that didn't exist with anything resembling this level of legal force before this determination was delivered. The third category is one that frequently gets disregarded in these discussions, and that is working Americans in their 40s and 50s who are still in the accumulation phase of retirement preparation. Individuals who aren't yet retired but who have dedicated years, sometimes decades, allocating to retirement accounts, choosing investment approaches, and organizing their financial choices around the belief that the regulations governing those accounts will maintain reasonably stability. The typical assumption is that highest court decisions about retirement primarily safeguard individuals who are already retired. This determination explicitly extends its safeguard forward. The reliance threshold applies not merely to previous choices, but to continuing ones. If you have dedicated 15 years allocating to a 401k because your jurisdiction provides advantageous taxation treatment for retirement distributions, and you have organized your accumulation rate, your investment composition, and your schedule around that treatment, those allocations represent years of reliance on an existing legal structure. The court's reasoning acknowledges that retirement preparation is a continuous procedure, not a singular instant. Every allocation made under a particular collection of regulations is another demonstration of reliance, and the safeguard the court has instituted extends to encompass that continuing procedure of preparation and choice structuring, not merely the choices that were structured decades previously. Now let's discuss the three-component constitutional examination, because this is the mechanism that will genuinely determine how this safeguard functions in application when jurisdictions attempt to modify retirement-connected legislation. Comprehending this examination is what distinguishes individuals who can authentically utilize this determination from individuals who only vaguely understand it exists. The initial element of the examination inquires whether individuals genuinely structured financial choices based on the preceding legislation. This is the reliance inquiry. Did you allocate to a pension infrastructure under a particular benefit calculation? Did you relocate based on taxation policies? Did you organize your accumulations around regulations that existed at the moment? If the response is affirmative, the initial element is fulfilled and the constitutional safeguard commences to apply. The subsequent element inquires whether the suggested modification would substantially damage the individuals who depended on the preceding regulations. Not every policy modification triggers the complete constitutional examination. The modification has to be substantial enough to meaningfully harm the financial strategies that were constructed under the initial structure. A trivial administrative modification is different from a fundamental reorganization of benefit determinations or a substantial new taxation on revenue that was previously excluded. The court is examining for damage that is genuine, quantifiable, and directly connected to the reliance individuals positioned on the legislation that is being modified. The third element is where authorities must bear its responsibility. If the initial two elements are fulfilled, the jurisdiction must prove a warrant compelling enough to supersede the constitutional safeguard established by individual reliance. Budget pressures exclusively are not adequate. The desire to modernize a taxation framework is not adequate. The warrant must be substantial enough, particular enough, and proportionate enough to exceed the recorded damage to individuals who structured their financial existence around the preceding regulations. This represents an elevated threshold, intentionally so, because the court acknowledged that without an elevated threshold, the safeguard signifies nothing. So, what should you genuinely execute at this moment? Because comprehending a determination is only the commencement. The genuine value emerges from converting that comprehension into tangible actions that safeguard your retirement. The initial and most crucial measure is recording. Commence establishing a transparent, structured record of the retirement-connected policies that presently apply to your circumstances. This signifies obtaining official records from your jurisdiction authority's platform, demonstrating how retirement revenue is presently taxed. It signifies preserving your pension registration records, your strategy summary descriptions, and any correspondence from your employer that describes benefit calculations or retirement conditions. It signifies maintaining records of your 401k or IRA account documentation, extending back as distantly as you can retrieve them. Why does this carry significance? Because the reliance threshold the court instituted requires documentation. If a jurisdiction ever modifies policies in a manner that damages you, your capacity to prove that you structured financial choices based on the preceding regulations will depend on possessing records that demonstrates what those regulations were when you structured your choices. A screenshot of a jurisdiction taxation policy webpage preserved today could become a vital piece of documentation in a future legal challenge. This isn't excessive caution. This is precisely the type of anticipatory preparation that converts a constitutional safeguard into an actionable one. The subsequent measure is to conduct a direct discussion with a financial consultant who is monitoring legal developments in retirement policy. Not every consultant will be immediately acquainted with the particular implications of this determination, but the superior ones will already be inquiring how it modifies the assessment of retirement preparation for their customers. Inquire your consultant particularly about how your present allocation approach, your distribution strategy, and your jurisdiction's taxation treatment of retirement revenue interact with the new reliance threshold. Inquire whether there are modifications to your extended strategy that could strengthen your position under the new legal structure. These aren't theoretical discussions. They are actionable preparation discussions that could meaningfully enhance your financial stability and retirement. The third measure, particularly for public sector workers, is to thoroughly examine your pension strategy records and contrast them against any legislative modifications that have been implemented to your infrastructure in recent years. If your jurisdiction has altered benefit calculations, modified retirement thresholds, or diminished cost of living modifications since you registered, those modifications may warrant closer examination under the new constitutional threshold. This doesn't signify you should immediately pursue legal response. It signifies you should be informed about whether the modifications that influenced your benefits might be the type of retrospective alterations the court's determination was specifically engineered to examine. Here is the broader reality that this determination compels us to address. Retirement stability in America has always depended on a measure of confidence. Confidence that the infrastructures individuals allocate to will still be present when they require them. Confidence that the regulations won't be recomposed after decades of preparation. Confidence that authorities which established the structure for retirement accumulations won't casually dismantle that structure when it becomes financially troublesome. For excessive duration, that confidence was largely unenforceable. Jurisdictions could contend sovereign authority. Legislators could assert budget necessity, and individual pensioners without the resources or legal standing to resist back effectively frequently possessed no genuine recourse. This determination modifies that dynamic in a manner that is both legally substantial and individually meaningful for millions of Americans. It states transparently and with complete consensus that the confidence individuals' position in retirement infrastructures isn't merely a social anticipation. It represents a constitutionally acknowledged interest that authorities must consider seriously before it acts in manners that betray it. This isn't a trivial matter. This represents the highest court of our nation, positioning its complete authority behind the concept that when Americans execute everything correctly, when they accumulate, when they prepare, when they structure responsible extended choices based on the regulations authorities itself established, authorities owes them something in exchange. It owes them stability. It owes them consistency. And now, for the initial time with this level of constitutional transparency, it owes them safeguarding. The narrative doesn't conclude with this determination. It commences here. Jurisdictions will respond. Some will implement grandfather arrangements to safeguard existing pensioners while implementing new regulations to future employees. Others will challenge their policy modifications directly up against the constitutional boundary the court instituted, compelling new judicial cases to establish precisely where that boundary sits in particular circumstances. Legal experts will debate the determination's scope. Financial strategists will modify their approaches, and legislators across all 50 jurisdictions will have to address the reality that the era of quietly recomposing retirement regulations without ramification is concluded. What you execute with this information at this moment carries more significance than most individuals acknowledge. The pensioners and employees who record their reliance today, who comprehend the safeguard this determination provides, and who arrange their retirement approach with this new legal environment in consideration are the ones who will be best equipped for whatever policy modifications emerge subsequently. Comprehension isn't merely authority in this framework. Comprehension is safeguarding. And the safeguarding only functions for the individuals who possess it. Distribute this with someone who is preparing for retirement or who is already there, because the choices that reshape financial futures seldom wait for everyone to synchronize. The highest court has communicated with complete consensus, and the message is transparent. The regulations of retirement are no longer something authorities can modify without addressing for the ramifications. This represents a victory decades in construction, and it belongs to every American who ever accumulated, prepared, and trusted that executing the correct thing would be